welcome to N8.7BN channel. Today we bring you a developing the legal theory that has captured national attention. The face-off between former Attorney General of the Federation Abubakar Malami and Nigeria's anti-graft agency, the EFCC. What are the allegations? What is Malami saying in his defense? And why does the case matter to Nigeria? Stay with us. If this is your first time visiting this channel, kindly subscribe for more videos, like and share. Abubakar Malami served as a Nigerian Attorney General and Minister of Defense under former President Muhammadu Buhari. Recently, the Economic and Financial Crimes Commission (EFCC) filed multiple charges against Malami, accusing him of money laundering and unlawful acquisition of funds amounting to several billions of naira. The charges also reportedly involve members of his family and associates, making the case even more sensitive and controversial. According to the EFCC, investigations revealed alleged movement of huge sums of money through bank accounts, use of companies and proceeds, purchase of high-value properties. The Commission insists that the investigations follow due process and that the former Minister of Sharia must answer the law like every other Nigerians. The EFCC said this case is part of its broader fight against corruption, regardless of status or political influence. Malami has denied all allegations, describing the EFCC's action as politically motivated witch hunt. Through his lawyer, he claims his fundamental rights were violated, bail conditions were unfair and excessive. The case is aimed at damaging his reputation. He also insists that he is innocent until proven guilty and says he will defend himself in court. The court drama and bail controversy. The legal batches has included court appearance, bail applications, disagreement over whether court orders were properly served. While Malami team says the court granted bail, the EFCC argues that no valid order was served, making his continued detention unlawful. This agreement has fueled public debate about the rule of law and judicial compliance in Nigeria. And the case goes beyond one man. It raises serious questions about accountability of former top government officials, independence of anti-corruption agencies, respect for court orders, trust in Nigeria's justice system. Many Nigerians watching closely to see whether justice will truly be served without fear or favor. As the trials continue, only the court will determine the truth. Until then, Malami remains a defendant, and EFCC carries the burden of proving its case. We will continue to follow development and bring you verified updates. If you found this report informative, please like the video, share your opinion in the comment, and subscribe for more credible Nigerian news and analysis. On Thursday, December 30th, 2025, arraigned the immediate past Attorney General of the Federation and Minister of Justice of Nigeria, Abubakar Malami San, alongside his wife Hajia Bashir Asebe and son Abubakar Abdulaziz Malami, before Justice Emeka White of the Federal High Court, Maitama, Abuja, over alleged money laundering offenses to the tune of 8.7 billion naira, which is 8,713,923,759 naira 49 kobo. The defendants were docked on 16-count charges bordering on conspiracy, procuring, disguising, concealing, and laundering proceeds of unlawful activities contrary to the provision of the Money Laundering Prevention and Prohibition Act 2022. At the commencement of proceedings, Prosecution Counsel Ekele Iheanacho-San informed the court that the matter was for arraignment of the defendant. My lord, this matter is for the arraignment of the defendant on 16-count charges dated and filed on December 23, 2025. We humbly pray that the charge be read to the defendant and their pleas taken, he said. Counsel to the defendant, J.B. Daudu San, raised no objections, following which Justice Nweti ordered that the charge be read. Count 1 of the charges read that you, Abubakar Malami San, and Abubakar Abdulaziz Malami between July 2022 and June 2025 in Abuja procured Metropolitan Autotech Limited to conceal the unlawful origin of the sum of 1,014,848,500 naira in a Sterling Bank PLC account when they reasonably ought to have known that the sum constituted proceeds of unlawful activities, hereby committing an offence contrary to Section 21C of the Money Laundering Prevention and Prohibited Act 2022. The punishable under Section 18 (3) of the same Act. Count 5 reads that you, Abubakar Malami San, Abubakar Abdulaziz Malami, and Hajia Bashir Asebe, an employee of Rahmaniya Properties Limited, sometimes in September 2024 in Abuja, conspired to disguise the unlawful origin of the aggregate sum of 1,049,173,000 naira 166 naira 13 kobo paid through the Union Bank account of Mithaq Hotels Limited, Jabi, between November 2022 and September 2024, contrary to Section 21 of the Money Laundering Prevention and Prohibition Act 2022, and punishable under Section 18 (2) and 18 (3) of the same Act. Count 6 reads that you, Abubakar Malami San, and Abubakar Abdulaziz Malami, between November 2022 and October 2025, indirectly took control of the aggregate sum of 1,362,887,872 naira 96 kobo paid through the Union Bank PLC savings account of the Mithaq Hotels Limited when they reasonably ought to have known that the funds constituted proceeds of unlawful activities contrary to Section 18 (2) D and punishable under Section 18 (3) of the Money Laundering Prevention and Prohibition Act 2022. Following the pleas, Iheanacho informed the court that the prosecution was ready for trial and requested a trial date. He disclosed that the prosecution had been served with a bail application by the defense a day earlier and sought time to respond. In response to Daudu urged the court to grant bail orally, contending that the alleged offences were bailable. My lord, having listened carefully to the 16-count charges, this is a proper case for an oral application for bail, he said, citing Abiola vs. FRN. The offences alleged are bailable and Section 216 of the ACJA does not mandate that an application for bail must be made in writing, he said. Opposing the application, Iheanacho urged the court to discontinuance of the oral bail requested. My lord, we oppose the oral application for bail. The case of Abiola vs. VFRN relied often by land skills inapplicable, he argued. He further submitted that the court must be guided by affidavit evidence. This is a court of record submission of counsel, no matter how brilliantly presented, do not amount to evidence and cannot replace affidavit evidence, he said, warning that granting the oral application will amount to ambushing the prosecution. On the gravity of the case, Ihenako stressed public interest and consideration that the charge before this honorable court orders and serious economic crimes involving complex financial network and public interest must be taken into account, he submitted, adding that the high office previously held by the first defendant did not entitle him to preferential treatment. In this ruling, Justice White held that the prosecution must be given the opportunity to respond adequately to the bail application having listed to the submission of the land counsel. The prosecution must be allowed adequate opportunity to respond to the judge ruled. He ordered the defendants be remanded at the Kuje Prison Center and adjourned the matter to January 2, 2026 for hearing of the bail application.